This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Grammar and spelling is not an issue. It's not an English exam, it's a law exam. It's a law exam for accountants, it's not a law exam for lawyers. So you need to show an overall appreciation of the legal principles, but there's no need to get into heavy detail. In fact, these cases, these stories I tell you, there's no need to get into the detail of the stories. I only tell you the story to really to bring it alive, to make it... If I just said Estrange and Graucob and told you nothing about it, that's just two people's names. There's no story involved. The story about the ship going to Jamaica and the deserting crew. If I said that performance of a contractual duty already owed is not sufficient to merit the title consideration brackets Stilk and Myrick, it doesn't mean anything. So you've got to illustrate the principle, but it's the principles that you must remember. It's not the story itself. The story is almost entirely irrelevant for your purposes, but it illustrates the principle, and it's the principle that you must remember. So don't worry. I don't worry about the facts of cases. I mean, I give you the story as though it were fact, and sometimes I'm not far off. Sometimes the facts that I give you are reasonably similar. Like the windmill case, it was about a windmill, and the helicopter case was about a helicopter. But 30 days, 90 days, 42 days, 18th of June, 1854, it doesn't matter. All right? It's not an issue. There's no need to sit there and... Actually, it was the 26th of June, 1854, wasn't it? And the 4th of July. And Florence Nightingale and the Crimean War. There, you don't need it. It's not necessary. The principle is, if an injured party is suffered as a result of notification of breach, they have three choices. They can either sue immediately, brackets Hoxton de la Tour, or they can carry on their part of the contract and then claim the contract price at the end, which is White and Carter Councils and McGregor, or they can choose to wait and hope that the other person will change their mind. But if they do choose to wait, and they may find that they then lose the right to take legal action. And that was Avery and Bowden. And it's the principles that you're remembering, not the facts. We're down towards the bottom of page 35, and we've just looked at rectification. I said that the word rectification comes from the same root as the word correct. It's interesting to note that one or two of you have now created a further word based on the word correct, as in correctify. This is not a word that you would normally find in the dictionary, but I admire your enthusiasm and your ability to develop the English language in your own particular way. So the rectification is to make correct, or to correct something which was otherwise wrong. There is a case, can I remember it? Henkel and Pape. It's not in your notes. Henkel and Pape. And it's about the sale of guns. Guns. Bang. About the sale of guns. And the two contracting parties had negotiated and discussed and arrived at an acceptable position, and the contract was then written out. And the contract said that we agree to supply the guns where 100 guns had previously been discussed but not agreed. What they had agreed was that there would be a supply of 3 guns, not the guns. And they wrote it in the contract as the guns, and therefore the seller said, we're in a contract to buy 100 guns here, to buy and sell. The buyer said, no, we agreed 3. And it said, well, look what it says in the contract. It says the guns. It doesn't say 3 guns. So it went to court, and the court said, well, actually you did agree, didn't you? You actually did agree to buy and sell 3 guns, just because it says in the contract the guns, not 3 guns, then we're going to rectify the contract. We'll rectification, and the court put the contract into the correct wording so that only 3 guns were then bought and sold. So they correctified it, if such a word might exist. Mareva, a Mareva injunction. Mareva is not an English word. I think an injunction, a Mareva injunction, is named after a case in which the Mareva injunction was sought, was asked for, or was awarded, I should say. And the Mareva injunction is where a company, for instance, is in difficulty, and a person is alleging that this company owes them money. If the company says to the court, can you adjourn the hearing, can you delay the hearing to give us a little bit more time to get some evidence together, then that could happen. The court may adjourn the hearing. So it delays it by, say, 2 or 3 months or whatever time period. During that 2 or 3 months, it is available for the company directors to take the assets of the company and sell them cheaply, or to put them out of reach of a subsequent liquidator, so that eventually when it comes to court there are no assets left to pay the creditors anyway. So Mareva injunction is where the court says, yes, we will adjourn the hearing, we'll delay it by 3 months, but you mustn't do anything with the assets of the company. You mustn't put them out of reach of a subsequent liquidator. It's a freezing order. The company is not freely able, and so the assets will be frozen, and the company cannot freely dispose of those assets except at arm's length. So a Mareva injunction, a freezing injunction, which is available to be granted by the court. Then we come to liquidated damages. Damages, you know, are at the discretion of the court. It's an award that the court will consider the remoteness, and they'll consider the measurement of damages. But you know, we can enter into a contract, Christina and I can enter into a contract, where within the contract it says, in the event of my breach, I will pay. So she's probably insisted upon this. In the event of breach of contract, Mike will have to pay me £100. So that's liquidated damages. It's a pre-estimate of the potential loss which would be caused in the event of breach. But it may take the form of a penalty. So Christina may say, in the event that Mike breaches the contract, then I shall have to pay her £1,000, but in fact the loss that she suffers is only more likely to be £100. The court would not accept the £1,000 as being a contractual term. They look at it and say, is it a genuine pre-estimate of the loss which would be suffered in the event of breach? If she cannot show that it is a genuine, realistic attempt at measuring the loss that she will suffer, the court will just strike it out and just say, no, we're not accepting this. This is not a liquidated damages clause. It is a penalty clause. And the courts do not like penalty clauses. If the court wants to award a penalty, they will do it, not the contracting parties. So penalty clauses are unreasonable pre-estimates of the loss to be suffered. Liquidated damages, if they are to be acknowledged by the court, they have to be a genuine pre-estimate. We have a couple of cases, Interfoto and Stiletto, Ford and Armstrong, and Dunlop and New Garage. Dunlop and New Garage was about a retail price agreement where Dunlop insisted that their tyres should not be sold for less than, I'll put a figure on it, should not be sold for less than £30 each. New Garage was buying Dunlop tyres and selling them for £25 each. And Dunlop said, we are suffering here, our reputation is suffering because people think that a Dunlop tyre is a cheap tyre, and that's damaging our reputation. So in the event that you choose to sell my product for less than we have agreed, you're damaging my reputation, and we'll estimate that the amount of the damage I suffer is £5. And the court accepted that. But if it's a penalty, the courts won't accept it. In the case Interphoto and Stiletto, Stiletto were renting pictures. Interphoto was a picture gallery which was made available its pictures for rental. And Stiletto were renting some pictures, and they rented 18 pictures according to normal terms. But within the contract it said that in the event of late return of any of these pictures, there would be compensation payable, liquidated damages payable. And the amount payable was £10 per picture per day. And Stiletto returned these 18 pictures. They returned them, I think, 36 days late. Well, if you work out £10 times 36 times 18, it works out to a tremendous amount, 6,400 and something, just for the late return of pictures. And they fought against it. Stiletto fought against it and said, no, we're not paying that much. We're not paying 6,000 for the late return of some pictures. And the court determined that not all the pictures were in equal demand. They were not all equally popular. Some pictures were bigger than other pictures, and therefore clearly £10 per picture per day was an unreasonable penalty. It wasn't a reasonable, genuine pre-estimate of the loss that would be suffered. So they struck out the clause and said, no, you're not having this £10 per picture per day. And they replaced it with £1 per picture per week, rather than £10 per picture per day. So the court will not accept penalties, but if you can show it is a genuine pre-estimate of the amount that will be suffered, the court will accept it. Sundry points, page 36, and this will get us to the end of contract law. Remedies, equitable remedies are discretionary. That is, you can't go to court and ask for an equitable remedy. You don't go to court and say, will you grant me specific performance, or will you grant me an injunction? You can go to court and ask for the court to help you. You say, I am suffering because of their actions. What can I do? And the court, in its discretion, may say, we'll give you a monetary award of damages, because if damages is sufficient, damages will be awarded. But Britney Spears from 6 o'clock in the morning till 1 o'clock the next morning is that you couldn't pay me enough. You could not pay me enough to compensate me for the personal agony that I would have to suffer. And therefore, the court says, no, money's not appropriate, let's have an injunction. So the court has the discretion to award equitable remedies. But you don't ask for them. The court may, in its wisdom, grant you an equitable remedy. It will never act in personam against the breacher. This involves contracts of personal services. So if the personality of the breacher is involved and crucial, the court will never grant a specific performance. They will never say, if David Beckham were to refuse again to play for LA Galaxy take him to court and say to the court, will you make him play for our football team? The court won't do it, because the court has no control over the quality of the performance which is then given. These singers, Poussard and Bettini, these singers, there's no control. You can't make somebody sing or perform because they just sing in a flat voice. They don't sing the right words. They don't sing the right opera. They're just a disaster. So the court will never say, you perform according to the contract, if it's a personal service contract, because the court is not able to control the quality of the performance given. What they may do is, in the case Warner Brothers and Nelson, Warner Brothers is the film company, Nelson is the correct name, the family name, of the very famous American actress Bette Davis. And Bette Davis, towards the end of her career, was still in contract with Warner Brothers, but Warner Brothers had stopped using her as their lead actress. And she was given an opportunity to become a lead actress at, say, MGM Studios. So she was going to leave leave Warner Brothers and go and work for MGM. And Warner Brothers said, no, you can't do that. You're breaking the contract. We are contracted with you and you will work for us exclusively. She wanted to go. They said no. They took her to court and said, can you help us? And the court said, yes, we can stop her from going anywhere else. We can't make you make her work, but we can stop her from working for anybody else. So they granted an injunction in favor of Warner Brothers, which prevented Bette Davis from moving to competition. Delay defeats equity. These equitable remedies of specific performance, injunction, rescission, rectification, Mareva injunctions. Delay. If you are slow, if you are late, if you are unreasonable, if you take an unreasonable time to bring to court a claim where you feel you are being injured, the court says, well, we can't give you an equitable remedy. Why on earth? What has taken you so long? Why have you left it for 4 years before you brought a claim claiming that you have been injured? So the doctrine of lache is the French word for delay, and I don't know why we call it the doctrine of lache. I don't know why we call it the doctrine of delay. But we call it the doctrine of lache. Delay defeats equities. Equitable remedies won't be awarded, they will not be awarded if a contract has been affirmed, if you have confirmed the contract. Affirmation, confirmation, for our purposes, the same thing. So, if you offer to buy some shares in a company on the strength of the invitation document, the prospectus, so you send in your offer and they accept your offer, and subsequently you discover that the details in the prospectus were incorrect, they were wrong. Now you may claim that you would not have bought those shares if you had known the correct details. It's unusual, but there may be something within the prospectus which has induced you into buying those shares. So you find out, having had your offer accepted, and you've been now granted or been sold these shares, you may find that in fact the detail in the prospectus is incorrect. What are you going to do? What you could do, I suppose, is at the next general meeting of the company you can turn up, and because it's a general meeting of the shareholders or the members of the company, you can then say to the chair of the meeting, excuse me, chair, I've been induced into this contract to offer to buy shares and you've accepted on the basis of false information in the prospectus. Can I sell my shares? Can I insist that you should buy my shares back? Do you think you could do that? Or would you expect the person sitting next to you to ask the question and you just stay quiet and hope that they get the right answer? And the answer to that is no, you can do neither. Because if you turn up at that meeting, you are confirming that you are a shareholder. So having discovered the mistake, if you turn up at a company meeting, or if you bank a dividend, or if you send in a vote by email or by proxy, or you appoint somebody to attend the meeting on your behalf, you are confirming that you are a member. So you are affirming this contract which could otherwise have been rescinded. Is that clear? Good. Rescission will not be awarded if it's not possible to restore the parties to their original pre-contractual position. Benita has invited me into a partnership arrangement with her, so we're now partners in the Benita and Company firm. And then after a period of time she says, let's convert ourselves into a limited company. So we do, it's not a problem, we convert ourselves into a limited company. Then I discover that in order to get me to become a partner, she has misrepresented a number of key matters to me, and I have been induced into this partnership contract by her false representations. Well, if it's a misrepresentation, I could normally claim rescission. I could turn the world backwards and restore myself to the original position. But now look at this, that we started as a partnership, we're now a limited company. And the liabilities of partners and the liabilities of members of a company are rather different. And the rights of creditors are different. The creditors in a partnership have got far more entitlement to claim against the personal wealth of the partners, whereas the creditors of a company don't. The situation is that it is not possible to put me back into a partner position because I'm not just undoing a partnership, I'm having to undo a company and then undo a partnership. So it's not possible to restore the people to their original position. And it won't, the court also will not award an equitable remedy if the interests of an innocent third party would be adversely affected. If an innocent third party will be damaged as a result of undoing a contract, the court won't let me undo the contract. And finally, the Limitation Act. Limitation Act says 6 years unless it's a specialty contract, in which case it extends to 12 years. And it says that if you have a claim, if you have been injured by somebody else's breach of contract, you should bring your claim to court within 6 years of the time that the right to take action occurred. If you damage me in the year 2010, I ought to bring my case to court no later than 2016. I may delay up to 2016, but I can't bring it after 2016. If there's a deed, if it's a specialty contract which is involved, then that extends to 2021. It becomes a 12-year statute of limitations. And if after 12 years on a deed, if I've not taken any action to recover the damage, the court won't let me bring an action now. It's too late. I've delayed. We have just one little exception to that, and that's the final case there on page 36. It's 6 years from the date that the breach could first have been discovered. There's a case called Lynn and Bamber, which is in your notes. Lynn and Bamber. What was the other Lynn case we had? What was the other Lynn case? Liana Yarachu. Gunthing and Lynn. Gunthing and Lynn. This one is Lynn and Bamber. And Lynn and Bamber concerns a particular type of tree. It's a fruit tree, a plum tree, and the particular type of plum tree is it's a purple Pershore plum tree. A purple Pershore plum tree. And one of the characteristics of the purple Pershore plum tree is that it doesn't carry fruit until it is 7 years old. So if you go to your garden centre and you buy some very young purple Pershore plum trees and you plant them and sit back for 7 years, and when it does bear fruit, you discover in fact that the plums that it is bearing are not in fact purple Pershore plums, they are a different type of plum. Then you go back to the garden centre and say, do you remember me? I bought some plum trees from you 7 years ago, purple Pershore, but they're not purple Pershore. I want my money back. And the court says, I don't even remember you, or the garden centre is no longer there, or people have disappeared, or the owner has now died, and somebody else has bought the garden centre there. But you are allowed to take action within 6 years of first being able to discover the breach. So in that purple Pershore plum trees, any time up to the time the trees were 13 years old, because only after 7 years do they bear, and then you have 6 years to claim. Trees. What else have we had? Trees this last day and a half. What other trees have we had? Who? We've had maple. Yeah, what was the case? What was the area of law? It's no good remembering the trees, no good remembering the birds in the trees unless you can remember the area of law. What's the collective noun for a group of sheep? Flock. The Maple Flock Company case. Flock is in the back of chairs. And you buy flock in great bulk, delivered in installments. And if the 16th is defective, it's a breach of warranty, not a breach of condition. But we didn't know that, did we? Until there was a breach. So what sort of term was it? French word for name. Nom. And when you say in French, my name is, you would say, mon nom. My name, mon nom, and whatever your name is. So innominate terms, Maple Flock Company is an illustration of an innominate term. What other trees have we had? Wolves. Seven Oaks, yes, Seven Oak, the Seven Oak case. What was the Seven Oak case, Jana? Christina knows. Don't you?
Yes, I was done with me.
Come on, tell me. What's the Seven Oak case? Liana? Sorry? Storing of film in a cave. Well done, Christina. Storing of film in a cave. It illustrates what? Recommend it illustrates who? Mischief rule. It illustrates the mischief rule. Why was the act passed? In order to prevent the fire hazard. It wasn't for the safe and comfortable storage of film. It was passed in order to limit or reduce the fire hazard, the mischief rule. So we've had Seven Oaks, we've had maples. Have we not had a case involving some very tall trees? Some maybe high trees? Central London Property Trust and High Trees House. Yeah, what was that illustrative of? Promissory estoppel. Well done. The doctrine of promissory estoppel, where a promise is given and acted upon, then the promisor cannot go back on the promise to the detriment of the promisee. Yeah, that's another one. Any other trees? Yeah, we've had the purple Persian plum trees, so we've got that one. Some of these ships were made out of trees as well. What?
How could this buyer prove that he bought these trees?
Well, do you not keep your invoices? When you go to your garden centre to buy some dahlias or some primroses, do you not keep the invoice for a period of 7 years? Do you not? Amazing. I don't know how the buyer could prove or not prove that. That's not within my role to tell you how the buyer could prove it. They did prove it, and it went to court. I can't think of any other trees that we've come across. Oh, yes, we had. Yes, the windmill, because the wooden shaft, but we've also had the case, what was Noah's boat called? The Ark, and the subject matter of that case, the case Hyllus and Arcos, was 2 years' supply of what type of tree? Russian redwood trees. I think there was another one, wasn't there? Can't think. I thought there was another one, but I can't remember it. Right. Enough of contract law.